And on to debate number 2. It was a historic day in the Rajya Sabha. The 3 criminal bills that replaced the IPC, the CrPC and the Evidence Act were passed, in fact, in the upper house after being passed in the Lok Sabha earlier. The government calls the new bills reformative and shredding the colonial imprint. Home Minister Amit Shah, while introducing the new laws, claimed that the bills align with the spirit of the Constitution and will focus on justice rather than punishment, while emphasizing how the bill will free people from the colonial mindset and its symbols. Listen in.
कई सालों से आईपीसी 163 साल से, सीआरपीसी 125 साल से और एविडेंस एक्ट 150 साल से जो ब्रिटिश पार्लियामेंट ने बनाए थे, वही एक्ट को आज हम उसी एक्ट से आज हम गवर्न हो रहे थे। नरेंद्र मोदी जी ने आजादी के 75 साल बाद इस देश में सारे कॉलोनियल कानूनों के अंदर उसको बदलाव कर समाप्त कर भारत की आत्मा को प्रस्तावित करने की शुरुआत। पहले ट्रेजरी के खजाने को लूटने का गुना, रेल की पटरियों को तोड़ने का गुना, अंग्रेज शासन के खिलाफ षड्यंत्र करने का गुना, इसकी प्रायोरिटी ऊपर थी। मानव हत्या की प्रायोरिटी और बहन बेटी के साथ अत्याचार की प्रायोरिटी बहुत नीचे थी, क्योंकि अंग्रेज शासन का ये उद्देश्य ही नहीं था। उसका उद्देश्य दंड देने का था। जो शासन के खिलाफ काम करते थे, उसका उद्देश्य जिनके साथ अन्याय होता है, जिन पर अत्याचार होता है, उसको न्याय देने का नहीं था।
Meanwhile, the opposition has called it a draconian bill and that it was a threat to democracy. Opposition has pointed out that the bill endangers civil liberties and claimed that it expands the limit of police custody under general criminal law from 15 days to up to 60 or even 90 days, depending on the offence. Many have also pointed out how wildly worded these provisions are in the bill, and they are open to misinterpretation as well. Opposition parties have also said that these quote-unquote draconian laws were passed in Parliament without the presence of the opposition.
सर, आखिर इस देश में कब तक ये चलता रहेगा कि अनस्पोकन रिजर्वेशन उन लोगों के लिए उनके पास पूरा पॉलिटिकल पावर है और एक अनस्पोकन रिजर्वेशन है दलित, मुसलमान, आदिवासियों के, इनको जेल में रहना पड़ता है। कि आखिर ये कैसे मुमकिन है सर कि आलाजाद के जो अक्सरियती तबके के लोग हैं, उनके पास सियासी ताकत है, माशी ताकत है, सोशल ताकत है, और मुसलमान और दलित आदिवासी जेलों में पड़े रहते हैं। अरे अगर आप 3 कानून लाकर इस्लाह कर रहे हैं तो कौन सा इस्लाह है? आप तो ताकतवरों का रिफॉर्म कर रहे हैं, गरीबों को इससे क्या फायदा हो रहा है?
कि आज जब भारत एक विश्व गुरु बनने के रास्ते पे चलना चाह रहा है, we are looking into the future where we are waiting to compete with the developed countries, and we cannot come up with draconian laws. We can either become an authoritarian state like China, or we can go where human lives, human values, our rights as enshrined in the Constitution for everybody, from a minority to an SC to the last person in the queue.
Just last year, one of the Supreme Court justices observed that in the absence of legislative debate, of opposition criticisms and ministerial answers, it was difficult for judges to interpret laws by understanding their legislative intent. So when even that is not possible for the judges, you can understand what a disservice to the country this government has done by bulldozing these laws through without even any pretense of consultation or discussion with the opposition. I find this truly a moment to start writing obituaries for parliamentary democracy in our country.
जो opposition थी वो सब बाहर है, important bills pass हो रहे हैं.
You're watching the News Hour at 10, debate number 2 on Times Now, Super Prime Time.
And for more on this, let's go right across to our guest. Joining us is Aman Lekhi, former ASG. Vikram Singh is former DGP UP. He was also part of the government panel. We have with us Sanjay Hegde, senior advocate, joining us as well as Shilpi Jain, a lawyer from the Supreme Court. Aman Lekhi, let me start with several of the controversial aspects. And we are just discussing the legal aspects and legal provisions in these 3 criminal code bills. And one of the criticism is that it gives immense and overriding powers to the police. Without going to the specifics as far as civil liberties are concerned, there are those critics who say that, look here, even with 2 weeks of police custody, there is so much that we see in terms of excesses, third degree, as far as the vulnerable, marginalized sections of society are concerned, particularly. What will happen if you make this 2 months for certain offences of police custody is the potential for that much more misuse of these legal provisions. How do you react to that, Amaniki?
Well, that is apparent in the way in which the recodification is in fact done. It shows the frivolity with which we fiddle around with law. We had a system in place and we substituted the system with a new one. That normally is recodification. Recodification is grounded in certain settled philosophical basis, which is completely absent over here. And it is apparent on three very important aspects. One, no deliberation prior to the legislative measures coming. Two, no rigor insofar as the expression of the intent is concerned. And three, the bewilderment which is going to follow with the substituted system which is in place. Now, the problem which you mentioned as to the excesses, the biggest restraint on excess is the principle of legality and legitimacy and proportionality. These are three basic tests. Legality means certainty. As far as legitimacy is concerned, it contemplates due deliberation, and proportion is a combination of the two to ensure necessity according to the circumstances. Now, because the very basis of this particular change is in some way lacking, the three principles are consequently infringed. And apart from the terms in which it has come, which terms in any case is lacking in many ways in clarity, the consequences of excesses following is more or less inevitable.
Okay, let me get in a response from Mr. Vikram Singh, former DGP. Vikram Singh, the government for its part, of course, says that there have been wide consultations, that for 4 years we've been consulting with various justices, various state governments, several IPS officers also, like yourself, have been consulted. And it's after those deliberations and over 150 meetings, I believe, that this law has been brought in. But there are still certain questions that are being raised as far as the provisions in terms of whether this could lead to misuse.
You are absolutely right. There was widespread consultation with law colleges, law institutions, honorable lawyers and the judges, and also various government functionaries, police officers, serving and retired. And then all the recommendations of the Law Commission and the judgments of the Supreme Court were incorporated, and there will always be criticism. But I find this to be totally people-friendly and with a wider sense of justice and fair play. Look at the FIR. The lodging of FIR has been made transparent and clear, whether it's online, whether it's by oral, or even if it's a zero FIR, within 15 days, it has to reach the destination. Now, to say that torture, now everything is based on technology. Forensic science units, forensic units would be go to every scene of crime, as also the arrest and seizures and searches will be videographed. This has never happened, and I can tell you that there is a lot of consternation and of course, apprehensions in the police department as to how they are going to handle this. Then arrests also. Any arrest will have to be approved by a deputy SP rank officer. So these are the checks and balances which will go to show that it will be officer oriented. And also the trial, that the investigation cannot linger on for years together, 90 days. Then 60 days for framing of charges. Then 30 days for the delivery of judgment. What could be more transparent and people friendly? Then apart from the FIRs, you see if a public servant is complicit and his government sanction does not come in 20 days, it will be presumed that the prosecution sanction has been given. Okay. Then the appeal to the governor would not take more than 30 days and to the president not more than 90 days. In that case, there will be no appeal after that in any court of law, as it happened in the case of many anti-national elements and in the case of the accused of the Nirbhaya case. So these are people-friendly cases. And in the crime that were never picked up earlier, organized crime for one has been identified, terrorism has been identified, and mob lynching has been identified. Deshdroh and Rajdroh have been defined.
Okay, I'll get into all those specifics because those are debating point in themselves when it comes to sedition, etc. But let me quickly get in a response from Sanjay Hegde, if we can, on that. Sanjay Hegde, you have Vikram Singh who says that these are people-friendly laws. There are safeguards that have been built in that did not exist earlier, and therefore this is a more desirable set of laws that are going to form the various codes now. Your response to him, Sanjay Jain.
Well, policemen are people. And if by Mr. Vikram Singh's definition, it's people-friendly means only policemen, then I would tend to agree with him. This is a law which has been designed by the policemen and the police departments. You have given them too much control. You have tilted it against the common citizen, and the consequences will be horrendous. Except those who can manage to get anticipatory bail, the rest of you are at the mercy of a policeman. And just let me give you an example. We were speaking about the sedition law earlier and how vague it was. Supposing I say something on this program that Mr. Vikram Singh doesn't like, and he files an FIR, do you think that a policeman in UP will be kind to me? No. They will see to it that I get the 90 days of custody that is allowed in the law, and it will be in installments. People will fear to speak. This has a chilling effect on everything. And when we speak of consultation, I know not of any substantial member of the criminal bar at the first instance who has been consulted. There have been many lawyers who have been at the receiving end of policemen, as well as who have gone to the courts. Have you consulted any user? No. The only users that you have consulted are the policemen and the bureaucrats.
No, judges, state governments also is what they say. But let me bring in Mr. Vikram Singh, because Mr. Vikram Singh, the government is saying something quite different. The government says that there is a distinction between Rajdroh and Rashtradroh. Just criticizing the government is not sedition, but criticizing what is, forms or integral part of the identity of India, the flag, so on and so forth. All of those aspects are what will now attract the new sedition laws. So do you think that Mr. Hegde is right in saying that this will have a chilling effect on free speech?
Mr. Sanjay Hegde is a very learned lawyer, and Mr. Lekhi and Sanjay Hegde are the people iconic from whom we learn the rudiments of law. But it's my painful duty to contradict Mr. Sanjay Hegde today that by no stretch of imagination can an FIR be lodged in this cavalier manner, and it will be investigated even in more casual manner. And rest assured, there is a supervision at the 3 tiers, and nothing like this even has the remotest ghost of a chance of being charge sheeted. Now the question that what is Rajdroh and Deshdroh? Rajdroh is something that you criticize the government of the day. It is not an offense any longer. But if you criticize the nation, the integrity and the sovereignty of the nation, well, there will be consequences, and there is a 7-year punishment for that. Rightfully so. But Mr. Sanjay Hegde, I wish I had that same pompous belief about myself that if I were to lodge an FIR, nobody in UP is going to, touch me with a barge puller, to the contrary, incarcerate you. No, nothing like this. UP is a vibrant state, and it's a democracy, and people are absolutely law-abiding, and the police officer is very professional police. To the contrary, I feel...
Mr. Vikram Singh, I just want to ask one thing to you over here, because you've headed the police in UP, and it's not just about UP, across the country. Do you think the average policeman is equipped to make that subtle distinction between what is criticizing the government and what is criticizing the country? Because, there could be various grey lines over here, grey areas over here, where one another could overlap.
There are 2 sections. One is this Rajdroh and Deshdroh, and there is murder and culpable homicide not amounting to murder. These are 2 sticky sections which even the most high and the mighty would find it very difficult to identify. And I feel it requires workshops, training courses, giving examples, and also repeated courses to get the concepts of law very clear. It will not come overnight. It will go over a period of time. And the nightmare of the police today is how to memorize the new sections of law, because what has become a part of the DNA is the old sections that even if one is half asleep, one were to ask question, one would rattle off the section of the IPC and the CrPC, 107, 116, 153, 144 in the CrPC, and in the IPC, 182, Dhara 96 se leke 106. But now all this is history. Today you will have to go back to school once again.
Shilpi Jain, one of the things that the government is also talking about is the total number of sections as far as the IPC is concerned. A has come down, and several of these aspects in terms of procedure, which cause procedural delay, have also now been reduced and hopefully will lead to speedier justice. Are you confident that that's going to happen?
What was required in criminal law justice system was police reforms, better implementation of laws. instead of doing anything about that, they've increased the powers of the police. It's almost become a police state now. Now, Mr. Vikram Singh is here. He will endorse this or deny, I don't know. But the fact is that in Delhi police, a 10th pass, he doesn't need to be a graduate. He doesn't need to be a 12th pass. He can qualify to join the Delhi police. Now, and it's likewise all over India. And the investigation in criminal cases is done by the lowest rung officials who lack caliber. Most of them are drenched in corruption. So given this combination, it's the charge sheet that comes out is not always totally trustworthy. It's shoddy, it's questionable, and now increasing the police remand from 15 days by almost 6 times. It's horrendous. What happens at the ground level? If it's a rich man, he will have a very comfortable stay during this police remand. And many of them, in fact, find an option by bribing the police and opt for police remand, because when they are in judicial custody, it's difficult to get as comfortable a stay. Now, when you increase it, the corruption will increase, the torture will increase, and in most cases, the torture will increase for the poor. Now, if it's the government wanting to settle score with somebody, at the police level, there is absolutely no room for any check in terms of torture. And this thing about electronic evidence, recording evidence by electronic evidence, by electronic means, I think it's very, very questionable. It's a knee-jerk reaction. They have not thought this through.
Okay,
the very basis of criminal law is that you can go to the court and say that the person has been tortured. Now here, the judge may choose to rely on evidence which is before him in the camera, but there will be a different story behind the camera, which will be difficult for the accused to disprove. Then trial of people who are abroad in their absence. We are making criminal trial ex parte. That means a person can be convicted without giving him the right to be heard. All these provisions have not been thought through. What will be the consequence? But ma'am, the government says
that will help to get those absconders who are outside of the country's jurisdiction, because that is a requirement as per certain extradition treaties are concerned. So do you think the
only
government
on paper? Have we been able to get any accused extradited in India, be it the arms drop case, be it the most heinous, because we don't have human rights in this country. That's the perception in Europe and America.
Okay, let me bring in Mr. Aman Lekhi. Mr. Aman Lekhi is nodding his head very vigorously. Do you think that these fugitive economic offenders, particularly the high-profile cases that we've seen over the last several years, I don't think I even need to name them, but do you think that there is a solid case to be made for such a provision, Mr. Lekhi?
First of all, I mean, I don't accept the fact that as far as we as a country is concerned, the human rights abuses are endemic, and as a system, we have to be denounced. It doesn't behove any Indian or a lawyer to actually talk about the Indian legal system like this. I dissociate completely with this particular remark first, and I think it's unfounded. Number two, coming back to this particular issue about extradition, please understand this very simplistic. The Home Minister, with due respect, has to be better versed in law, because these are very intricate questions, Mr. Singh has correctly said, and a lay person is least qualified to speak, and his speech in Parliament disclosed the fact that he was basically ignorant about fundamental concepts. As far as extradition is concerned, even if you convict a person, it's not necessary that the place where you're seeking extradition from, it will necessarily follow, because there are various tests that have to be satisfied before the extradition actually takes place, and conviction is one of the issues, but not the decisive issue. So mainly because this conviction will not necessarily lead to extradition. And this simplicity and the confusion which comes around it is apparent. You mentioned about the distinction between Deshdroh and Rajdroh. And Mr. Singh pointed out that as far as the law is concerned, today, now, criticism of the government is not sedition. What is missed is, even under the old section, explanation 2 and explanation 3 made it absolutely clear that criticism of the government is not sedition. And the paradox here is that the government, which was in the forefront using 124A, defended 124A rightly. I personally feel sedition should be there. Is now being defensive and saying that 124A should not have been there. Now, why were they using it in the first place? They should be in the forefront saying we used it. It's a relevant provision, and we personally think that we should apply it. So this distinction between Rajdroh and Deshdroh is completely misconceived, because as far as this question is concerned, Deshdroh is still there. Treason. One of the other interviews is saying treason is there, sedition is there. Both are offensive to the state, and they should exist. So the long and short of this is, these are technical issues. It comes back to the first point. These are technical issues. Those versed in the law should be dealing with it. and those knowledgeable in the law should be speaking about it. So those not versed in the law have dealt with it, and those who have no idea about the law are speaking about it, and the chaos is going to follow today.
All right.
So this is not the way in which you deal with something as substantial as this.
All right. Let me also, in fact, introduce Aditya Agarwal, who's a SC Bar Association president and also was part of the panel. In fact, Sanjay Hegde was maintaining a short while earlier, Mr. Agarwal, that there weren't enough practicing lawyers who were part of the consultation process. I want to get in your thoughts on that, as well as the question about whether these provisions relating to fugitive economic offenders, etc., and even the points relating to the differentiation between Rajdro and Deshdro that have been made are correct. Those concerns expressed by the panelists are correct. Where do you stand on this, Mr. Agarwal?
I support the amendments. The madam, I joined late. I'm not aware of her name.
Shilpi Jain. Shilpi Jain is
now police raj will be there, all these things, and now bribery will be there. That totally, it is false and frivolous. The people will be, when they have run away, the provision earlier, what was happening? For 10 years, 15 years, other accused persons were undergoing trial. For their conviction may be for 3 years, but the case was going on for 15 years, only on the ground that 1 or 2 accused persons are not appearing in court. Now, the trial, in their absence, if they are not traceable, the trial will go on. And what they are loser. Now, who have run away, their people, their relatives, that, oh, he has run away, but why he is being punished? Why? Why he has run away? He should have faced the trial. So these things have been made so that even the accused person should not be undergoing such agony of being accused person for many years. Police bringing them from jail or from police custody. That is not correct.
Okay.
The cases should be decided.
Okay. Shilpi Jain, would you like to respond to that, since he's responding to the point that you specifically made, and of course Mr. Lekhi has also countered you on several of those points?
You know, if you see the practical data, I think the data speaks for itself, whether we have human rights in this country or not. A jail which otherwise should accommodate about 3,000 prisoners will have a capacity of up to 15,000. Foreigners, I have a few foreign clients who are under trials and in custody. They are not permitted to make a phone call at home. If we go to the court says, show us judgments on the point, which means that for months and maybe years, they are not permitted either by the courts or by the jails to make a call to the families abroad. As far as the food is concerned, I would rather not speak about it. There is total absence of sunlight in all the rooms. But I think it is kind of a presumption that in a country like ours, these things are not to be asked for prisoners.
Okay.
So.
Okay. Let me come back to the provisions of law that have been made. I mean, certainly there may be scope for a lot of improvement in different areas. But I want to bring in Mr. Vikram Singh on the entire issue of the inclusion of terror. Now, there are those who are asking that we have UAPA which exists to deal with terror. Is there any specific reason, Mr. Vikram Singh, that we brought it into this particular code as well? And what about the conflicts potentially that may exist if we have two sets of laws?
My first observation is that all the ingredients of Makoka and Guchkoka have also been incorporated in the Bharatiya Nyaya Sanhita, because we do not have these acts in many of the states. Therefore, the best practices naturally have been adapted in the statute, and as also UAPA can be used as also with these sections. Like in novel cases today, what do? We use the IPC sections, we use the National Security Act, we invoke the provisions of the UAPA simultaneously to give a deterrent and give a deterrence, and also a strong message that crime will not pay and anti-national activity, terrorism will be very, very counterproductive for those who even think on those lines. Now, having said that, therefore, for the sake of uniformity, it is good to have certain definitions, certain punishments right across the country from Kashmir to Kanyakumari.
Okay.
UAPA may or may not be invoked depending upon the severity and the quality of the evidence that has been garnered by the investigators.
Okay. Sanjay Hegde. Sanjay Hegde would like to respond to that.
Well, we can keep on debating it, but we are heading for chaos. And the only persons who are going to benefit largely are the lawyers. So on that note, I can thank the Home Minister and this unthinking government for providing us a lot of work, but this is work which could have best been avoided. You wanted a systemic change, you wanted to change the names, please go ahead. But right now, what you have done is to cut off your head to solve a headache. That's the level of things.
All right, we'll have to leave it there. Aman Lekhi, Vikram Singh, Sanjay Hegde, Shilpi Jain and Adish Agarwal, I'd like to thank all of you for joining us this evening. Certainly, it appears and remains to be seen really how courts will interpret these various provisions and also what the possible further complications could be as far as law is concerned that several lawyers on the panel are telling us. We'll have to see how all of this pans out in coming days. Thanks so much for joining us.